Morning.
Morning, Judge.
How are you?
I'm good. How are you doing?
I'm well. They should be logging on shortly.
I'm good.
Oh, thank you very much. If you like, don't argue with the judge, just understand this is not guilty of anything. This is just for telling you what the exact charges are. Okay?
Can you hear me in the jail?
Yes, Your Honor.
Thank you. Okay, let's see. On the record in the matter of the state of Michigan versus Siovante Lawrence Spencer. Counsel appearance, please.
Thank you, Your Honor.
Okay.
Jonathan Thurman, Office of the Public Defender, here with Mr. Spencer. who is appearing from the Lansing Police Department lockup. We waive his in-person appearance this morning.
Today was the date and the time scheduled for arraignment. I do have a felony complaint here. The allegations are that on or about July 19th, 2025, at the area of 929 Bench in Lansing, Michigan, that the defendant allegedly committed the act in count 1 of domestic violence and or knowingly assaulting a pregnant individual, third offense notice. It states here that the defendant did allegedly make an assault and battery upon a Cassandra Marie Garcia, a resident or former resident of his or her household, or an individual with whom he had a dating relationship, and that this was done contrary to Michigan Compiled Law 750.812. There's a third offense notice. It says, take notice that the defendant was previously convicted of assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.812 on or about May 19, 2021 in the 30th Circuit Court, County of Ingham, State of Michigan, and again by violating Michigan Compiled Law 750.812 on or about May 19, 2021 in 30th Circuit Court, County of Ingham, State of Michigan. And therefore, upon conviction, the defendant is subject to an enhanced sentence under MCL 750.815. Restitution may be ordered upon conviction, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. The maximum penalty on this is a felony 5 years in prison and or $5,000 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is an habitual offender, second offense notice. It says, take notice that the defendant was previously convicted of a felony or an attempt to commit a felony in that on or about May 19, 2021. He was convicted of the offense of assault with a dangerous weapon in violation of Michigan Compiled Law 750.82 in the 30th Circuit Court for Ingham County, State of Michigan. And therefore, the defendant is subject to the penalties provided by Michigan Compiled Law 769.10. That enhances the maximum penalty to 1 1/2 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charge? The maximum penalty read on the charge, which was enhanced by a third offense notice, and then the habitual offender second offense notice, which now makes the maximum penalty up to 1 1/2 times the maximum sentence. Do you understand that?
Yes, Your Honor.
Okay. You have the right to be represented by counsel, and Mr. Thurman is here today from the Office of the Public Defender to represent you for the purposes of your arraignment only. You have the right to remain silent. Anything that you say, anything that you put in writing can be used against you. You have the right, if you cannot afford an attorney, to make a request to have the Public Defender's Office represent you at the expense of the public. You have the right to proceed in this matter to a preliminary examination because the count that you are being charged with is a felony. You have the right at the time of that examination to have the prosecutor put forth evidence that would establish that they have sufficient probable cause that the felony being alleged was committed, and then probable cause sufficient to charge you as the individual who committed that felony. You have the right to have that preliminary examination within 21 days of today's date, because that's the date that you are being arraigned, unless you waive that 21-day timeline or the court finds good cause to go beyond the 21-day timeline. You understand your right so far?
Yes, Your Honor.
You have the right to proceed to trial and the right to a jury trial. You are presumed innocent until proven guilty. You have the right to have the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt at trial before you are deemed to be guilty. You have the right again to maintain your silence at trial, not have that silence be used against you, or you can waive your silence and testify at your trial if you'd like. You have the right to see, hear, or question any witness the prosecutor calls to testify against you, the right to subpoena witnesses to testify on your behalf. Do you understand each of those rights?
Yes, Your Honor.
Okay, is he requesting the public defender's office to represent him?
He is, Judge.
The court's going to enter a plea of not guilty on your behalf. You're currently scheduled for a probable cause conference before me, Judge Kristen Simmons, and it's going to be on August 1st at 1:30 p.m. in courtroom 4. You do have the option of appearing via Zoom for the probable cause conference. You have a preliminary examination before me in person at the court, August 8th at 8:30 in the morning. Did you receive your notice to appear?
Yes, Your Honor.
Are you currently employed?
Yes, Your Honor.
Where?
M&M Moving and Storage.
What's your home address?
Well, I'm gonna have to go to my sister's house, my 1114 West Washington.
Okay, so you live with the protected party, is that the issue?
Yes, at 929 Bench Street.
What's your phone number?
It's 989-578-1304.
Are you currently on probation or on parole?
No, ma'am.
You said no?
No, ma'am.
You can address bond, counsel.
Thank you, Your Honor. Having spoken with Mr. Spencer this morning, the court's aware of his criminal history, but he informed me that he has no failures to appear any court dates. So I think the court can be assured that he'll return to court. He's lived in the Lansing area for his whole life. He's working, as he noted, for the court. He has family in the area, his mom and his sisters. He's been able to provide an alternate address to the court where he would be residing with his sister. So for those reasons, we would be requesting a personal bond in this matter with any conditions that the court deems appropriate.
I don't have any information as to whether or not he has in fact never missed court in the past. He does have quite an extensive criminal history and an abundance of charges of domestic violence and or assaultive crimes, many of which were dismissed, but I think we both know, or I should say we all know, that a lot of times that's dismissed because the victim fails to appear. But the amount of times that he's been either charged and or convicted of domestic violence indicates to me, in conjunction with the way this matter was charged, which is a third offense notice with an habitual offender second offense enhancement, that there is some threat to the public safety. So personal recognizance bond will not be granted. Bond will be set in the amount of 10,000, 10% with GPS tether. While out on bond, you have the following conditions. You're not to use, purchase, or possess alcohol or marijuana or controlled substance. You're not to travel outside the state without prior approval of the court. You're not to have a firearm, ammunition, or weapon of any kind. You're not to have contact with the protected party, which is Cassandra Marie Garcia. You're not to be within 2,000 feet of wherever she is. Do you understand that?
Yes, Your Honor.
You're not to have contact directly or indirectly, no contact via third party, no contact via text message, no calls from the jail, no communication of any kind with Ms. Garcia while this protection order is in place. Do you understand that?
Yes, Your Honor.
You must report to pretrial services within 48 hours of your release from custody, and you must appear to all of your court dates on time. Do you have any questions about your bond conditions?
No, Your Honor.
Any additional matters for the record, counsel?
No, Judge, thank you.
You're all set.
Call me.
On the record in the matter of the state of Michigan versus Thurman Hakeem McCall, counsel appearance.
Thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Mr. McCall, who is currently walking up to the camera. We waive his in-person appearance this morning.
Are you Mr. McCall?
Yes, Your Honor.
Okay, Mr. McCall, I have a felony complaint here that I'm going to arraign you on. The allegation that on or about July 18, 2025, at 6099 South Martin Luther King Boulevard in the city of Lansing, Michigan, that you did make an assault or assault and battery upon a Lanisha Shante Shirley, an individual with whom you had a dating relationship, and that this was done contrary to Michigan Compiled Law 750.812. There is a third offense notice. The allegations state, take notice that the defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.812 on or about April 28, 2016, in the 60th District Court, County of Muskegon, State of Michigan. And again, by violating MCL 750.812 on or about April 30th, 2024 in the 54A District Court, County of Ingham, State of Michigan. And therefore, upon conviction, will be subject to an enhanced sentence under MCL 750.815. Restitution may be ordered as this offense may have resulted in damage to another individual's personal property, a physical injury, or death to another individual. Count 1 has a maximum penalty of 5 years and or $5,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is, however, an habitual offender fourth offense notice. It states, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about March 6, 2023, he was convicted of the offense of weapons carrying concealed in violation of MCL 750.227 in the 20th Circuit Court for Ottawa County, State of Michigan, and that on or about May 15, 2023, he was convicted of the offense of controlled substance possession of methamphetamine in violation of MCL 333.74032B1 in the 14th Circuit Court for Muskegon County, State of Michigan. And that on or about March 6, 2015, he was convicted of the offense of escaping awaiting trial for felony in violation of MCL 750.1972 in the 14th Circuit Court, Muskegon County, State of Michigan. And therefore, the defendant is subject to the penalties provided by MCL 769.12 that enhances count 1 to a maximum penalty of life if the primary offense has a penalty of 5 years or more. Your primary offense does have a maximum penalty of 5 years or more. You understand the charge and the maximum penalty? Do you understand the charge and the maximum penalty, sir?
Oh, yes, ma'am. Yes, Your Honor.
You have the right to counsel. Mr. Foreman is here to represent you while you are being arraigned. But you do have the right to have an attorney represent you at all stages of the criminal prosecution and at all of your court appearances, and if you're questioned by law enforcement. And so if you can't afford to hire an attorney to represent you, you can make a request to have counsel appointed at the expense of the public. Do you understand that?
Yes, ma'am.
Okay, thank you. And so, is he requesting public defense to represent him?
Yes, Judge.
The court will enter a plea of not guilty on your behalf, but I will advise you that you do have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way to a jury trial. You are being charged with a felony. You do have the right to have a preliminary examination. You have the right to have that examination within 21 days of today's date, unless you waive that timeline or the court for some reason finds good cause to go beyond the 21-day timeline to reset it further. You're currently scheduled for a probable cause conference before Judge Stacia Buchanan on August 1st at 2 p.m. You can appear via Zoom or in person for that.
Yes,
You also
ma'am.
have the right, you have the right to have that preliminary examination, and that examination is scheduled on August 8th before Judge Buchanan in person at the court at 9 a.m. Did you receive a notice to appear?
Yes, ma'am.
Thank you. Okay. You have the right at the time of your preliminary examination to require the prosecutor put forth evidence that would establish that they have sufficient probable cause that a felony was committed and sufficient probable cause to charge you with the felony. Do you understand that?
Yes, yes, ma'am.
Okay. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. And you have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will go all the way to a jury trial. You are presumed innocent until proven guilty, and you can maintain your innocence and take this matter all the way to trial and require the prosecutor prove beyond a reasonable doubt each element of the charges being brought against you. You have the right to maintain your silence at trial and not have silence be used against you, or you can waive your silence and testify at your trial if you like. You have the right to subpoena witnesses that will testify on your behalf, the right to see, hear, or question any of the prosecutor's witnesses. Do you have questions about those rights, sir?
No, Your Honor.
Are you currently employed?
No, Your Honor.
You're unemployed? How do you support yourself?
Because I'm standing the men's mission right now, and they help me with my SSI because I was in a wheelchair for 5 years, and I just started walking, so I ain't able to get a regular job like everyone else right now. But they working with me in my house and everything else, Your Honor.
So you'll be looking for employment is what you're stating.
Once everything come through, they say I'm able to look for a job because SSI, they say you cannot get no job while you waiting, I think. And my case manager told me, so it's gonna mess that up for me. So
Okay. What address are you staying at?
what'd you say, Your Honor?
What address are you staying at?
The city rescue mission for the men's, right there across from capital city Myers. I don't know the address. You got the address?
It's 430 North Larch, Your Honor.
Thank you.
Okay. Sorry about that, Your Honor.
You're fine. Okay, let's see. What's your phone number if you have one?
517-299-3015.
Are you on probation or on parole?
No, ma'am.
Counsel, you can make your bond motion.
Thank you, Your Honor. I had the opportunity to speak with Mr. McCall. The court's aware of his prior criminal history, but he has lived in the Lansing area for the last 2 years or so. He currently doesn't have an address and would not be able to meet bond, is my understanding. It does seem, and I think it's clear to the court, that he has some medical issues, as he just expressed, and I imagine that being in the jail would exacerbate those medical issues. For those reasons, we would ask the court to consider a personal bond in this matter. Thank you.
You have any other court cases pending at this time?
No, ma'am.
I have a bond recommendation here from the prosecutor's office. It does indicate there's a concern for the protection of the public. It states that the defendant is either on parole, probation, or has other pending criminal matters. He says otherwise. I'm not sure why they have different information than he does. It states here the crime charge involves violence towards another person. The defendant has a history of violent behavior towards the victim and a history of threatening and or harassing behavior towards victim or witnesses, and there was an intimate partner relationship. These allegations involve a crime in front or in the presence of children, and that there are other factors, including attempts to isolate the victim to prevent the victim from reporting the crime. The people are requesting $150,000 cash surety bond and a no contact order. I would say for the record that the defendant is facing at this point up to life in prison because of the third offense notice and then the habitual offender fourth offense because of how many times he's been convicted, and then also because of the amount of violent offenses that he has on his criminal history. It's a pretty extensive criminal history. So a personal recognizance bond based on these factors would not be appropriate. There is a threat to the public safety. I don't have any information as to how or if he has, how many times or if he has missed court in the past. All I have now at this point is his criminal history, which is extensive. And then information from the prosecutor's office that he is either on parole, probation, or has another pending criminal matter. So I don't know why they would know that and he does not. I reviewed his criminal history and I don't necessarily see anything that would indicate to me that he's on probation. I do see a 2023. Oh, wait a minute. Well, I did see a 2023 conviction that he was supposed to be sentenced on, and then I see a 2024 conviction. So I'm not sure what they're referencing. I don't see anything here that tells me that he's on probation at least. Yes.
I apologize. For the record, I'm looking at anything in our internal system, and I'm seeing that his last cases were resolved in 24 with a time served sentence. So perhaps the prosecutor's office has information from outside the county that I don't have, but certainly nothing within the county that would indicate he's on probation or parole or has another pending case at this time.
Yeah, there's nothing that I have on his criminal history that would indicate to me that he has something else pending, at least not at this time. He is indigent. I think that's apparent by some information that he's provided. So I don't know that $150,000 cash surety bond is necessary to secure his return to court and to protect the public, but the court will not grant a PR bond. Bond is set in the amount of $10,000 cash surety with GPS tether.
Excuse me, Mr.
Mr. McCall, not right now.
Okay.
While on bond, you have the following conditions. You're not to have contact directly or indirectly with the protected party, Lanisha Shante Shirley. Do you understand that?
So this is a felony, not a misdemeanor?
This is definitely a felony. You're definitely facing up to life in prison right now.
Ma'am, because they said.
Mr. McCall, I'm going to advise you not to say anything further at this time.
Sorry about that. Sorry about
Your
that.
Honor, if you could please spell the name of the protected party just for our records.
I have LENASHA for Lanisha. N as in Nancy, that is. So LEN as in Nancy, ESHA. Last name Shirley, common spelling on that.
Thank you.
You're not to be within 2,000 feet of wherever she is. You're not to have contact directly or indirectly with her. No third-party contact, no contact via text message, Instagram, social medias of any kind. You cannot call her from the jail. The prosecutor's office will check your jail calls. So you shouldn't try it. You shouldn't try to use someone else's jail PIN number to make the phone calls. That doesn't work either. Do you understand that?
Yes, ma'am.
Okay. You need to report to all of your future court dates if you're released from custody. You're also not to travel outside the state without prior approval of the court. You're not to use drugs or alcohol without a valid prescription. You're not to possess a firearm, ammunition, or weapon of any kind, and you must report to pretrial services within 48 hours of your release from Ingham County Jail. Do you understand that?
Yes, Your Honor. But I got stabs
Yeah.
in my face. I got
sorry?
stitches in my
Mis-
face. And I got a sprained ankle, man. I ain't no threat to nobody or the public.
Mr. McCall, I'm going to advise you to not speak any further at this time.
I ain't,
Okay.
you know.
Okay, I recognize you probably have or need some medical attention about the stitches if they're not dissolvable. I don't know anything about the sprained ankle, but I'm sure you can send a kite to get that looked at. If the allegations in this complaint are true, that I don't think that either the sprained ankle or the stitches prevented you from finding your way in custody today. So I think that you'll get that treated while in custody so that we can maintain protection of the victim, the public, and make sure you get back to court timely. You're not actually eligible for a personal recognizance bond due to the nature of the charge and your prior criminal history, okay?
Ma'am, they didn't tell me about none of
Mr.
this.
McCall, I'm going to advise you not to speak any further at this time.
Because I ain't did nothing. I ain't did nothing.
Mr. McCall, we'll sort that out, okay?
I cannot do that when I'm in prison. I can't do that, sir. I've been.
You're
I
not
said
in
this.
prison. You're not in prison.
Y'all telling me I'm facing life. I'm just something new that I ain't did.
Mr.
nothing.
McCall,
They said,
Mr. McCall, we're going to get an attorney assigned for you. They'll be able to discuss things with you as soon as possible, okay? But for right now,
I'm not
speaking back to the
understanding
judge
this.
isn't
This
helping
is-
your situation.
Like being locked up, I'm not doing nothing wrong. Y'all. Like I gotta get my Section 8. I got custody of my child. Like just really a step back right now, and I ain't did nothing wrong. But people had made false allegations.
Mr. McCall, I'm going to advise you not to speak any further at this time.
Ma'am, excuse me, Your Honor. I'm not trying to be disrespectful, nothing like that. It just
Well,
right now.
let me stop you. Let me stop you because again, I just heard your attorney at least 4 or 5 times advise you that it's not in your best interest to speak. And so I'm going to remind you of your right to remain silent because anything that you say can be used against you. Now, if you want to not listen to the attorney's advice and speak and ask a question, feel free to do so at this time.
You should ask some questions, ma'am.
That's it. That's if you do not want to listen to your attorney's advice. You can feel free to ask me whatever you or tell me whatever you want, but you've been advised by your attorney multiple times that you should not speak.
Man, okay, Your Honor. I just was trying to tell you, like, I had just got hit yet last night because they said the charges might be dropped.
Mr. McCall, I'm going to advise you very strongly to not speak about the charges or the case in any way.
Okay. So this means I lose my Section 8 and then my custody rights of my son, right? Because I'm going to jail right now, sir.
You're not under a sentence, sir. So you need to get a bondsman and see if you can post a bond. Your attorney once assigned can review the file with Judge Buchanan next week at your probable cause conference and make a new bond motion. But at this time, bond is set at 10,000 cash surety. Okay.
I don't have that. I'm standing in the mission, man. I really don't have that. And
I recognize that. The people were requesting $150,000. I did not grant that because I think that is extremely high under the circumstances. of your financial condition, not extremely high under the circumstances of the allegations, okay? So I did take into consideration that you are indigent. So nonetheless, I don't believe that we're getting any further advancing by going back and forth. My bond is set. You're all set.
Go follow me. I go straight, it's fine.
On the record, in the matter of the people of the state of Michigan versus Stephanie Maria Lera, counsel appearance.
Thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Ms. Lera. We waive her in-person appearance for today's hearing.
Here's Stephanie Marie Lera or Maria Lera.
Correct.
Okay, Ms. Lera, I do have a felony complaint that I'm going to arraign you on. Okay, the allegations here are that on or about July 19, 2025, at the area of 3030 Trappers Cove Trail, which is in the city of Lansing, Ingham County, state of Michigan, that you allegedly committed the act of home invasion first degree. The allegations are that you did break and enter or did enter without permission a dwelling located at 3030 Trappers Cove, apartment 3A, and while entering, present in, or exiting, did commit an assault. And while entering, present in, or exiting the dwelling, a Nevaeh Bustinza was lawfully present therein, and this was done contrary to Michigan Compiled Law 750.110A2. This is a felony. The maximum penalty is 20 years in prison and or $5,000 in fines, and a consecutive sentence may be imposed under the law for any conviction arising out of the same transaction. There is, however, an habitual offender. Let me see what's going on with my computer here. Okay, there is an habitual offender fourth offense notice. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies in that on or about May 21st, 2014. She was convicted of the offense of financial transaction device stealing, retaining without consent in violation of MCL 750.157N1 in the 30th Circuit Court for Ingham County, state of Michigan. And that on or about April 17, 2014, she was convicted of the offense of financial transaction device, illegal sale or use in violation of MCL 750.157Q in the 56th Circuit Court for Eaton County, state of Michigan. That on or about April 17, 2014, she was convicted of the offense of financial transaction device, illegal sale, use in violation of MCL 750.157Q in the 56th Circuit Court for Eaton County, state of Michigan. Therefore, the defendant is subject to the penalties provided by MCL 769.12. That enhances the maximum penalty on the home invasion to life. Do you understand that?
Yes, ma'am.
Okay. You have the right to be represented by an attorney. You are represented by the Office of the Public Defender today for the purposes of your arraignment only, but you do have the right to an attorney and the right to have an attorney with you if you're questioned by law enforcement, and the right to be represented by counsel at all of your court appearances during this criminal prosecution. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at no expense to you. Do you understand that?
Yes.
Is she requesting the public defender's office to represent her, counsel?
Yes, Judge.
The court is going to enter a plea of not guilty on your behalf. You have the following rights. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. But again, I just entered a plea of not guilty on your behalf because you have requested the public defender's office to represent you. They need to file an appearance and get some discovery, okay?
Okay.
You have the right in this matter to have a preliminary examination within 21 days of today's date, unless you waive the 21 days or the court finds good cause to go beyond those 21 days. You have the right at the time of the exam to have the prosecutor establish on the record sufficient probable cause that the felony was committed, and then sufficient probable cause to charge you as the person who committed the felony. Do you understand your rights so far?
Yes, ma'am.
You have the right to the presumption that you are innocent until proven guilty. And you have the right to take this matter all the way to a jury trial and have the prosecutor first prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to maintain your silence at trial and not have silence be used against you. Your right to see, hear, or question any witness that they call to testify against you, and your right to subpoena witnesses that will testify on your behalf. You also can waive your silence at trial and testify on your own behalf. You understand that?
Yes, ma'am.
Do you have any questions about those rights?
No, ma'am.
On this file, you're currently scheduled for a probable cause conference before me. Judge Kristen Simmons is going to be on August 1st at 1:30 p.m. You may appear via Zoom or in person for that. You also have a preliminary examination that's scheduled August 8th at 8:30 that you must appear in person for. Do you understand that?
Yes.
I have here also people of the state of Michigan versus Stephanie Lera. This is file number 25-01694 SM. Counsel, may I have your appearance on this one as well?
Thank you, Your Honor. Jonathan Foreman, Office of the Public Defender. And if I could just get the case number on that one more time, I apologize.
No problem. 25-01694.
Thank you.
In this matter, there's a misdemeanor complaint. The allegations are that on or about March 28, 2025 at 2514 West Jolly Road, which is in the city of Lansing, state of Michigan, that you did make an assault or assault and battery in count 1 against a Gianni Rosario, that is. And then there's a count 2 of assault and battery against a Michaela Hatley. Both at the same date and time. The allegations are that these are misdemeanors, 93 days and or $500 in fines for each count 1 and 2, and a consecutive sentence may be imposed under the law if the assaults were committed in a place of confinement. Do you have any questions about those charges and the maximum penalty there?
No, ma'am.
Okay, your rights to trial and to be represented by an attorney apply in this matter as well. The court will enter a plea of not guilty on your behalf, and note that you are requesting the public defender to represent you, okay?
Okay.
In this matter, you are scheduled for a pre-trial before Judge Cynthia Ward on August 12th at 2 p.m. Did you receive your notices to appear on these files?
Ma'am.
Are you employed?
I am.
Where?
I work at Alliance OBGYN.
What do you do there?
I'm a clerical staff.
What's your phone number?
517-899-7406.
And your address?
It's 1503 East Saginaw Street, Lansing, Michigan, 48906.
Are you on probation or on parole?
Oh, ma'am.
Yeah. Other than these two files, do you have anything else pending at this time?
No, ma'am.
Counsel, you can address bond.
Thank you, Your Honor. I had the opportunity to speak with Ms. Lera. I'll note that although she is charged as a habitual fourth, it seems that all those prior criminal offenses relate to approximately the same criminal offense date and the same type of conduct, all of which is non-assaultive. I believe the court read all three were financial transaction device cases. My client has never failed to appear for court before, is my information. She's lived in Lansing for her whole life. She lives with 3 kids and she has a good job, as she just described to the court. As I noted, I'm not aware of any assaultive criminal history. So for all those reasons, I would request a personal bond in this matter.
I just want to clarify, although the criminal charges are all the same type, or the criminal convictions that are, they are definitely not the same transactions. They're different cases, different courts, different case numbers.
Sorry, I didn't mean to imply otherwise, Your Honor. I think that the conviction date on all three were the same, unless I misheard.
It looks like there was one from the 17th, I'm sorry, of April 2014, but that was in the 56th Circuit Court. 30th Circuit Court, she had May 21st, 2014, and then the other one was April 10th. So around the same time of all those convictions, but not the same date, not the same courts.
My apologies, Your Honor. I
No
misheard.
problem. Okay. All right. So, but I did note that there was no prior criminal convictions or history for assaultive actions. However, now we have one pending assault and battery, which looks like she was supposed to appear previously for an arraignment. However, I don't believe we had an accurate address, so that would make sense why she didn't appear if she was summoned. And then we also have, maybe there wasn't a summons, there was a warrant. Okay, and then I also now have allegations of a home invasion, which carries a hefty penalty if convicted. However, I did review the affidavit of probable cause. I do not believe that that charge presents a threat to the public safety. My understanding of the facts, at least those that are alleged for the purposes of getting the complaint issued, was there was some exchange regarding Miss Lera getting her child out of that home. So I am going to grant the request for a personal recognizance bond. However, I'm granting it with some very clear instructions. And you are assigned to me for the felony matter. So you will be held strictly to these conditions. If you can't comply, you may have to lose your job and sit in jail. Do you understand that?
Yes, ma'am.
Okay, you have the following conditions. Number one, you need to come to all of your court dates. You need to be on time. You're not to engage in any assaultive or threatening behavior. Do you understand that?
Yes, ma'am.
You're not to travel outside the state unless you first get approval from the judge that is over your case before you can leave. Do you understand that?
Yes, ma'am.
Not to possess a firearm, ammunition, or weapon of any kind. Not to use drugs or alcohol. Unless you have a valid prescription. You're not to possess a weapon or a firearm or ammunition. I'm going to issue a no contact order in the misdemeanor and in the felony cases. In the felony file, you're not to have contact directly or indirectly through with a Nevea Bustinza. And I recognize this person may or may not have a relationship with your child. So you must be careful because you can't even send a message through your child to them. Do you understand that?
Yes, ma'am.
And you're not to be at the address or within 2,000 feet of wherever Miss Nevea Bustinza lives, works, or goes to school. Do you have any questions about that?
No, ma'am.
On the misdemeanor file, there will be a no contact order in place for the protection of the alleged parties or alleged victims, Gianni, Rosario, and no contact with the Michaela Hatton. Do you understand that?
Yes, ma'am.
All your bond conditions will be consistent on both files. So again, you must report to court, no weapons, no assaultive behavior, no drugs, no alcohol, no travel without prior approval of the court. On the felony, you must report to pretrial services within 48 hours of your release. Do you have any questions at this time?
No, ma'am.
Any additional matters for the record, counsel? Oh, did I
No,
say
Your
what
Honor,
the
thank
bond
you.
was? I probably should say exactly what the bond is. I'll give you 10,000 personal recognizance on the felony. On the misdemeanor, it's 1,000 personal recognizance. You're all set, ma'am.
Thank you, Your Honor.
Thank you, Judge.
This is the people of the state of Michigan versus Marquise Cook. And then file number 25-02075, appearance, please.
Thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Mr. Cook. For the purpose of arraignment today, we waive his in-person appearance.
Okay, you're Mr. Marquise Cook?
Yes, ma'am.
Okay, I have a misdemeanor complaint that alleges that on or about May 26, 2025, at the area of 717 Jessup Ave, that's in the city of Lansing, Ingham County, state of Michigan, that you allegedly committed the act of an assault or assault and battery upon a Kanika Elizabeth Miller, who was an individual with whom you had a dating relationship with, contrary to MCL 750.812. So that's domestic violence charged as a misdemeanor, 93 days in jail and or $500 in fines is the maximum sentence, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty, sir?
Yes, ma'am.
Okay. You have the right to be represented by an attorney. You're represented today for your arraignment, but you do have the right to have an attorney at all of your court appearances. And if you're questioned by law enforcement, if you can't afford an attorney, you can make a request to have the public defender represent you at the expense of the public, okay?
Yes, ma'am.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter is going to go all the way to a jury trial. And you are presumed innocent, sir, until proven guilty. You can maintain your innocence, take this matter to trial, and have the prosecutor first prove each element of the charge of domestic violence beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
You have the right at trial to question any witness they call to testify against you, the right to subpoena witnesses that will testify on your behalf, the right to present evidence at trial that you believe show defense or defenses to the charges being brought against you, and the right to waive your silence and testify at your trial if you'd like. You're currently scheduled for a pretrial conference before Judge Stacia Buchanan on August 18th at 10:30 in the morning. You may appear via Zoom or in person. Did you get a notice to appear?
Oh, yes, ma'am.
Okay. And do you have any questions about your rights at this time?
No.
Okay, all right. Is he requesting the public defender?
He is, Judge.
Okay, the court's gonna enter a not guilty plea on your behalf. Are you employed?
Yes, ma'am.
Where?
Cornerstone Caregiving and Dave and Buster's.
What's your phone number?
517-940-3799.
Kanika Miller lives at 717 Jessup with you?
No, she came to my house.
She doesn't reside there.
No.
Are you on probation or on parole currently?
No, ma'am.
Do you have any other criminal matters pending?
No, ma'am.
Counsel, you can make allocution.
Thank you, Your Honor. I had the opportunity to speak with Mr. Cook. He was straightforward with me about a prior CCW that he has, but he has no assaultive criminal history, is my understanding. And he's never failed to appear for court before, is also my understanding. I believe this was a summons case, and that he was picked up, or sorry, that this was not a summons case, that this was a warrant case, and that he was picked up on that warrant. He's lived in the Lansing area for his whole life, as he just described to the court. He works 2 jobs. He lived with his mother at that 717 Jessup Avenue address. So I believe he has, so he has strong community ties. Given all of that, we would request a personal bond in this matter.
Bond is set in the amount of 500 personal recognizance. While out on bond, you're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court. There's a no contact order in place for the protection of the alleged victim, Kanika Miller. You're not to have contact directly or indirectly with her. Do you understand that?
Yes, ma'am.
Are you not to be within 2,000 feet of wherever she is? Do you understand that?
Yes, ma'am.
You're not to possess a firearm, ammunition, or weapon of any kind. You're not to use drugs or alcohol unless you have a valid prescription. Let's see. And if I did say, you do need to make sure you come to all of your court dates, okay?
Yes, ma'am.
Do you have any questions about your bond conditions?
No, ma'am.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
You're all set, sir.
Thank you.
Your Honor, can I get you to
Yes.
repeat the bond? We must have missed it.
500 personal recognizance.
Thank you, Your Honor.
No problem. On the record in the matter of the people of the state of Michigan versus Keith Blor. Counsel, can I have your appearance?
Thank you, Your Honor. Jonathan Foreman, Office of Public Defender, here with Mr. Blor. We waive his in-person appearance today.
Okay, Mr. Blor, you're here for a arraignment on a violation of your conditional release from custody. The allegations are that on or about July 19th at 1:30, that you violated more than one of your bond conditions, one being that you were not to use, purchase, or possess alcohol while out on bond. It states here that when taken into custody, a PPT resulted in an alcohol content level of 0.28. It also states that you were observed in the passenger seat of a vehicle driven by a Melissa Bassinger that pulled into the driveway of 1705 Dock Strong, which is Bassinger's residence. And there is a bond condition as a result of a pending assaultive matter before this court that prohibits you from having contact directly or indirectly with Ms. Bassinger. So you have the right in this matter to have a contested hearing on your allegations of violating your bond. If you're found to be in violation of your bond conditions, that is considered a contempt of court issue, and your bond can be revoked pending the decision or ruling on the underlying matter. Do you understand that?
Yes, Your Honor.
You also could be sentenced to a term of 93 days in jail for each violation and or up to a fine of $7,500. Do you understand that?
Yes, Your Honor.
Okay. Counsel, do you have any information about who his other matter is before?
If you can just provide me one moment, Your Honor, I do. It appears to be in front of Judge Flores, Your Honor, with a sentencing date pending on August 8th.
Okay, and your client wants to plead not guilty as to the violation?
Yes, Judge.
Okay, the court will enter a plea of not guilty. This matter will be set for a probation violation hearing. I'm sorry, set for a bond condition hearing, violation hearing, not probation. A PA 53 violation will be set by the court before Judge Flores. At this point, it's probably going to be the same date as a sentence, but I'm not sure. You can address bond.
Thank you, Your Honor. Having spoken with my client this morning, he informed me that he's been maintaining a residence at 904 Dornell Avenue, where he's been staying with his sponsor. He says he has a job starting on on July 25th doing maintenance at McDonald's maintenance. We would request a personal bond here, Judge. I don't believe there are any allegations of violence, so I don't have any reports in front of me, but I didn't hear the court list that as a potential violation, any assaultive or behavior or anything of that nature.
Well,
So
he's being sentenced on what charge?
I believe a domestic violence first offense, Your Honor.
You are right.
Well, just to be clear, the nature of why the police were there, they were called in reference to a possible fight or assault. That's first. And so there are allegations of some assaultive action, even in the violation request, but by the mere nature that he's out on bond, which is not a question at this point. And then when he's taken into custody, he has a blood alcohol content, which is in violation of his bond, and he's with the person that he's not supposed to be with because he's supposed to be sentenced in less than 2 weeks for assaultive or domestic assault on that person. It's not an indication to the court that he follows court orders or that he would even be a good candidate for probation when he sees Judge Flores on the 8th. But that's a decision for Judge Flores to make. The decision I have to make now is if he is a candidate to be released on his own recognizance, and he's not because his own recognizance doesn't help him to follow court orders. So bond will be set in the amount of $5,000, 10% with GPS tether. All other bond conditions that were previously set, including a no contact order, will continue. Any additional matters for the record?
No, Your Honor, thank you.
You're all set, sir. Okay, I printed this affidavit and then I must have accidentally stuck it in somebody else's file.
Sit down. Oh, understand. Ridiculous. Or,
Okay, on the record in the matter of the state of Michigan versus Antonio Luis Butler, counsel appearance.
Thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Mr. Butler. We waive his in-person appearance for today's hearing.
Okay, you're Antonio Butler.
Yes, ma'am, I am.
Okay, Mr. Butler, I have a felony complaint here. The allegations are that on or about July 17th, 2025, at the area of 557 South Chestnut Street, City of Lansing, Ingham County, that you allegedly committed the act in count 1 of controlled substances, possession of cocaine, heroin, or other narcotic. The allegations are that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine, contrary to MCL 333.74032A. The felony has a maximum penalty of 4 years and or $2,500 that $25,000 that is in fines. There's an habitual offender second offense notice. It says take notice that the defendant was previously convicted of a felony or attempt to commit a felony, and that on or about September 20th, 2007, he was convicted of the offense of larceny in a building in violation of MTL 750.360 in the 30th Circuit Court for Ingham County, and therefore the defendant is subject to the penalties provided by MCL 769.10. And that enhances your penalty in count 1 to 1 1/2 times the maximum sentence on the primary offense or a lesser term. Do you understand the charge and the penalty and the habitual offender enhancement on that penalty?
Yes, I do.
You have the right to counsel. Mr. Foreman is going to represent you today for your arraignment. You have the right to have an attorney represent you at all of your future court dates, and the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire your own attorney, you can make a request to have the public defender's office appointed to represent you at no expense to you. Do you understand that?
Yes, ma'am, I do.
You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You can plead guilty, you can plead not guilty, or you can stand mute. If you stand mute, this matter is going to go all the way to a jury trial. You have the right in this matter to proceed to a preliminary examination because you're being charged with a felony. You have the right to have that exam within 21 days of today's date unless you waive the timeline where the court finds good cause to go beyond the 21 days. At the time of the exam, you have the right to have the prosecutor establish that they have sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the individual who committed the felony. You're currently scheduled for a probable cause conference before Judge Stacia Buchanan on August 1st, 2025 at 2 p.m. You have a preliminary examination before Judge Buchanan on August 8th at 9 a.m. and you must appear in person for that, okay?
Okay.
Did you get a notice to appear?
Oh, yes, ma'am, I did.
You have the right to the presumption that you are innocent until proven guilty. You can maintain your innocence and take this matter to trial. You have the right to a jury trial. And at the time of your trial, you can maintain your silence and they cannot use that against you. You have the right to question by way of your lawyers any of the witnesses that are called to testify against you. Your right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you. Or you can waive your silence at trial and testify on your own behalf. Do you understand those rights?
Yes, I do.
He's requesting the public defender, is that correct?
Yes, Judge.
Okay, the court's going to enter a not guilty plea on your behalf. Are you currently on probation?
No, ma'am, I'm not.
Are you on parole?
No, ma'am, I am not.
Do you have any other court matters pending?
Yes, ma'am, I do. On the same day, I gotta go to court for malicious destruction of property.
So you're out on bond.
Yes, ma'am.
Okay, so it's likely you'll also get a PA 53 violation as well, a potential bond violation for this new case.
My information, Judge, on that is that he was seen yesterday and granted a PR bond on a PA 53.
Oh,
Yes, ma'am,
okay,
I
so
will.
that was already addressed, but they didn't address the underlying issue. Got it. Okay, let's see here. What's your address?
1823 Hoyt Ave.
Are you employed?
No, ma'am, I have an interview on Monday.
Interview where?
Manpower,
What's your phone number?
517-894-8014.
You can address bond, counsel.
Thank you, Your Honor. I had the opportunity to speak with Mr. Butler and listen to the court's reading of the complaint. Although he does have a felony, and this is a half second, it appears that's a very old felony. I believe the court read 2007 is the date there. He informs me he's never failed to appear for court. Although there was a case pending right now, this is a nonviolent allegation. As he noted, he has a job interview on Monday. He's lived in Lansing for his entire life. So we would request a personal bond with any conditions that the court deems appropriate to ensure both Mr. Butler's and the community safety.
Bond is set in the amount of 1,000 personal recognizance while out on bond. All of your previous bond conditions that were set in your case that's pending will apply here as well. And that includes no violent or harassing conduct, no travel outside the state, no use of drugs or alcohol, no possession of weapons, ammunition, or firearms. You need to report to pretrial services within 48 hours of your release, and I am going to order that you participate in substance abuse testing and monitoring while out on bond. Do you have any questions at this time?
Will I have to pay for that, the testing or whatnot?
Yes.
Okay, all right.
Any additional questions?
No, ma'am.
Okay, you're all set. Thank you. That's all I have.
Thank you, Judge.
That's all. Thank you.